Good afternoon. My name is Donald Tobin, and I'm the Dean of the University of Maryland, Francis King Carey School of Law. On behalf of Maryland Carey Law, I want to thank you for joining us online today. I am proud to be part of the Agricultural Law Education Initiative and appreciate the excellent work the legal specialists do every day for the farming community, as well as the work they do in the classroom and in the field, teaching and mentoring the next generation of lawyers. This year has brought unprecedented legal challenges for the agricultural industry. Farmers and lawyers who advise them have been forced to employ creative solutions despite labor, marketing, and supply chain restraints to maintain the supply of healthy and nutritious food upon which we all rely. The pandemic has highlighted the fragility of our food system and the importance of supporting all of those who grow, process, and distribute our food. This event was created 6 years ago to provide a forum for farmers and environmental advocates to discuss their unique legal challenges and to give lawyers, educators, regulators, and lawmakers an opportunity to learn more about the legal impact and become better informed advisors and advocates. The Agricultural Law Education Initiative decided, despite a change in the format, to hold this event this year in order to provide a forum to discuss the complex legal issues which protect Maryland's food system and natural resources. Over the course of this webinar series, you will hear from experts on a variety of legal issues, ranging from monitoring air emissions from confined animal feeding operations to the legal strategies being used to protect the Chesapeake Bay. The legal landscape Maryland farmers traverse can be arduous and is ever-changing, but I hope the spirit of this event and information you will learn throughout this series will demonstrate the University of Maryland is committed to helping farmers navigate these legal frameworks, and even in these uncertain times, to not just survive, but thrive. I appreciate the opportunity to be with you today to support this important work, and we look forward to working with you to provide legal support to the farming community. Thank you for joining us today.
Okay, thank you for those remarks, Dean Tobin. We appreciate that. I will go ahead and introduce our panelists for this afternoon. We have Charles McLeod, founder of the McLeod Law Group. We've got Jonathan May, an Assistant Attorney General for the Maryland Department of the Environment, and we have Denise Keener, Assistant Secretary for the Maryland Department of the Environment. I will let our experts take it away.
Thank you.
Okay, does that look like it's up?
Yes.
Great. All right, good afternoon. I'm Jonathan May. I'm an Assistant Attorney General representing the Maryland Department of the Environment and the Water and Science Administration. And the department is the state certification agency in Maryland for issuance of water quality certifications. So we're here today to talk about the Conowingo Dam and the water quality certification issued by the state. So I wanted to begin with sort of the framework, the legal framework for water quality certifications. First of all, we're looking at the Federal Clean Water Act, Section 401, which states that to obtain a license for any federal activity, or to obtain a federal license or a permit for any activity that may result in a discharge to the United States, the applicant first has to obtain a water quality certification, a WQC, from the state in which the discharge has, where the discharge is located. So the WQC is a certification that the activity itself, the permitted activity, will comply with state water quality standards and other appropriate requirements of state law. So it's a very powerful tool that's been reserved to the states by the Clean Water Act. And any conditions that might be imposed in a certification are automatically incorporated into the relevant federal license or permit. There is a limitation in Section 401, and the state has to act within a reasonable amount of time, not to exceed 1 year from the receipt of the request for certification, and either issue the certification, include conditions in that certification, or deny certification. And if the state fails to meet that reasonable time, then the federal agency can determine that the state has waived its certification authority entirely. So we're here to talk about the Conowingo Dam, and it's a dam that fully spans the Susquehanna River, approximately 10 miles north of the confluence with Chesapeake Bay. The river drains an enormous area in Maryland, Pennsylvania, and New York. And then that comes down to, all that water comes down to a dam located again just above the Chesapeake Bay. So for nearly a century now since it's been constructed, both its placement, where it's located, and the way the facility has been operated have just fundamentally altered the natural river system. Currently, the dam is owned and operated by Exelon Generation Company as a hydroelectric power facility. So that requires a federal permit from the Federal Energy Regulatory Commission, FERC. And in August of 2012, Exelon applied for a new long-term license to continue operating the dam. And that's the trigger for Section 401, the application for a new license. And so Exelon is required to obtain a certification from the state, and first applied in 2014 for that certification. Now, initially, the state issued a public notice of its intent to deny certification. Did not have sufficient information for certain water quality impacts. So Exelon withdrew the application and then resubmitted it within 90 days. That cycle occurred again. Subsequent new requests for certification were submitted and then withdrawn for the next 3 years, until the most recent new request for certification was submitted in 2017. So in April 2018, MDE issued a WQC for the dam. And again, in context, this is the first opportunity in decades that Maryland had the opportunity to impose conditions on the dam's operation. My colleague Denise Keener will address those impacts a little bit more specifically, but in the certification, there were conditions for issues such as sediment and nutrients, the flow regime, both minimum flows and controlling maximum flows, as well as controlling the speed with which Exelon can vary between the two. Provisions for fish passage, trash and debris removal, and other conditions to improve aquatic habitat. So shortly after, within 30 days after issuance of the water quality certification, Exelon filed several challenges to the WQC. First, Exelon filed an administrative challenge pursuant to Maryland's administrative appeal procedures, contending that the water quality certification was too burdensome, went beyond the scope of the state's authority under the Clean Water Act, and was just unduly expensive for it to comply. The two other groups, the Lower Susquehanna Riverkeeper and Waterkeepers Chesapeake, also filed administrative challenges, and contending the opposite of Exelon, that the state did not go far enough and needed additional conditions to address certain water quality impacts. And those remain pending. Exelon then did two other things. It filed suit in two different places. First, in state court, on the Circuit Court for Baltimore City. That case has since been dismissed, and Exelon has filed an appeal, so the case remains pending at the Court of Special Appeals. And then Exelon also filed suit in the United States District Court for the District of Columbia. A motion to dismiss that also remains pending in that case. So while these challenges were playing out, the federal landscape, or the legal landscape surrounding Section 401, began to change. And that brings up the fourth challenge that Exelon ultimately filed. It petitioned FERC directly in February of 2019, asking FERC to find that the state had waived its authority under Section 401 because it did not act within a reasonable time, 1 year from the initial request it received in 2014. And Exelon was relying on another case, a new decision that was issued in January of 2019 called Hoopa Valley Drive. Now, for years before Hoopa Valley, it had been practice, particularly at FERC with hydropower relicensing, for applicants to withdraw, submit requests for applications, withdraw them, And so long as they resubmitted an application for a water quality certification within 90 days, that reset the clock under Section 401. Now, in Hoopa Valley Tribe, the court ended up finding that 2 states had waived their certification authority. They had entered into a written agreement with the applicant there to coordinate a withdrawal and resubmittal of the same request for a period of 10 years. And the court in that case found that that violated 401 and resulted in a waiver of authority. And although the court itself said that decision was narrow in terms of the facts before it, FERC has since, in other hydropower relicensing decisions, applied the analysis of Hoopa Valley Tribe and found that these other cases were sufficiently similar that they have found waiver as well. And that is what Exelon asked in its petition with FERC, that it fell within the facts of Hoopa Valley Tribe, and Maryland has waived its authority. The second sort of shift in the legal landscape occurred again at the federal level. In 2019, the Trump administration issued an executive order directing EPA to promote energy infrastructure projects and to streamline the 401 process. And EPA did so and released a new regulation in June of this year, which became effective a few months ago. And it does that. It operates to narrow the scope of authority, of state authority under Section 401, the scope of what conditions can appropriately be included in a 401, and adds more process for states to go through in order to issue valid Section 401 water quality certifications. And it also addresses the timing element as well, the 1-year deadline. So it's amidst this, this landscape, the litigation continued, and despite the challenges that Exelon had filed and the changes in the legal landscape, it did remain at the table, and the parties were in fact ordered to mediation through the Court of Special Appeals. So after a number of months, those negotiations were successful, and ultimately a settlement was reached in October of last year. The settlement really is in 2 parts. There's a settlement agreement itself that has what you could refer to as non-licensing issues. They are commitments on the part of Exelon that don't necessarily relate to the operation of the dam itself, but may include monetary compensation to mitigate or offset the impacts from the dam, to fund projects to improve water quality. Because they don't relate to dam operations, they would not be incorporated as permit or as license articles in the new FERC license for the facility. But the second part of the settlement agreement were proposed license articles themselves. They do relate to the operation of the dam. They include fish passage obligations, controls on the flow through the dam. Because they relate directly to dam operations, they would be included in the FERC license, and those require FERC approval. So what the parties did jointly on October 29th of 2019, they filed a joint offer of settlement with FERC, and that is the formal process for obtaining FERC approval. FERC issued a public notice and invited comments on from interested persons through January of 2020. A number of comments were received, both in opposition to and in support of the settlement. Exelon and MDE responded to those comments. And now that is where the settlement agreement stands. It's waiting for FERC to act on that offer of settlement. Ideally, from the perspective of the state, FERC would approve the settlement and incorporate the proposed license articles into the new 50-year license for the facility. That will, if that occurs, the settlement will become effective, and all of Exelon's obligations will kick in. If that does not happen and FERC accepts less than or does not approve all of the proposed license articles, there will be a new process. Exelon and the MDE have the opportunity to try to renegotiate, to see if they can come up with a different outcome. However, the state retains the right to terminate the agreement in the event that they cannot renegotiate. If that occurs, then the original water quality certification stands and the litigation will continue. But from the state's perspective, getting a formal agreement in place with enforceable commitments on the part of Exelon is preferable to continuing litigation for a certain number or unknown number of years to really an uncertain outcome. So right now we eagerly await a decision from FERC and see where we go.
Thank you, Jonathan. That was a great explanation of a complex topic in a short amount of time, so I appreciate it. At this time, I wanted to mention, I was remiss not mentioning at the outset that anyone who has questions for the presenters, please type them in the chat box. We have reserved time at the end of the webinar to address questions, so feel free to type them in, and then I'll dole those out at the conclusion when we have time. At this point, I'm going to turn it over to Denise Keener. So Denise, if you want to turn your video on, we will pull your slides up.
Very good. Thank you. As Sarah indicated, I'm Denise Keener, and I am one of two assistant secretaries at the Maryland Department of the Environment. And my role today is to walk through in a little bit more detail than Jonathan May did, key provisions in the settlement agreement between Maryland and Exelon. I really do appreciate the opportunity to be here and to, at the end of the panel discussion, take any questions that anyone might have. Next slide. Before I go through the key provisions in the settlement agreement, I thought it would make sense to set the stage a little bit by discussing the water quality impacts of the dam on the Susquehanna River and on the Chesapeake Bay. Every condition that is in a water quality certification ultimately has to track with water quality and the impacts of discharges from the dam on water quality. And our settlement agreement also, the provisions of the settlement agreement also tracks with water quality related impacts. So as Jonathan May mentioned, the dam, the Conowingo Dam spans the entire width at the place that it is located of the Susquehanna River. And it's only 10 miles from the entrance to the Chesapeake Bay. A little factoid that maybe many people don't realize is that the lion's share of fresh water entering the Chesapeake Bay comes down through the Susquehanna River Basin, down the Susquehanna River and into the bay. Another factoid that I think a lot of people don't realize is that prior to the late 1920s, the dam was built in between 1926 and 1928. The 460 plus mile long Susquehanna River was a major spawning tributary for American shad and river herring. And it's also a place along the East Coast where American eels grew to maturity in fresh water before they headed out to the Sargasso Sea to spawn. It's important to recognize that the dam operated and has operated for 90 years as a peaking facility, and that for about 44 of those years, there was no accommodation for upstream fish passage. Until 1980 or so, another interesting factoid about how the dam is operated, there were times during prior to the 1980s where the dam was actually shut off. I should say that the river was shut off downstream for sometimes several days at a time during drought periods as the dam operator would build the reservoir filled with water in order to generate energy by then releasing the water through the turbines. The dam also trapped until about 2014, I'll say, sediment and nutrients that entered the river upstream of the dam. I think many people recognize, but just to underscore that the reservoir behind the dam is now infilled and it no longer has storage capacity. And that means a couple of things. One of the things it means is that it's not retaining materials that are moving downstream. The other thing it means is that during large storm events, there can be the scouring of sediment, including sediment containing nutrients from behind the dam. And those materials travel downstream a relatively short 10 miles into the Chesapeake Bay. Finally, trash and debris, most of which is woody debris, gets trapped behind the dam and that also can be released during large storm events. We've seen over the past, I would say 5 years or so, a couple of times when there were rather large quantities of trash and debris that ended up downstream in the Chesapeake Bay. And in the Susquehanna River itself, there are water utilities that have had their drinking water intakes blocked by trash and debris that was suddenly released as a result of a storm event. Next slide. So what does that mean? What does all of that mean for the health of the river and the bay? Well, one key thing it means is that the river that's upstream of the dam doesn't have the aquatic life that it should have, because the Conowingo Dam, along with some other dams too upstream of the Conowingo Dam, effectively blocked migratory fish passage for a very long time. Species that are important for the life cycle of freshwater mussels, American eels in particular, as I mentioned earlier, were blocked from upstream transport as well. The reason I mention freshwater mussels is that freshwater mussels in a freshwater system play an important role in filtering pollution. So the loss of American eels moving upstream for a very long period of time also is a factor in the loss of freshwater mussel populations upstream of the dam, which effectively means that the system itself isn't operating ecologically the way it should operate, with those mussels helping to contribute to a sustainable pollution filtration mechanism that is very natural and should be part of the river system. Other populations, I mentioned American shad and river herring, also seriously depleted populations of those fish species upstream of the dam. The river downstream of the dam also doesn't have what it should have with regard to aquatic life because of in part, the way the dam operates as a peaking facility. Effectively, a peaking facility works to store as much water as can be stored, and then essentially on a daily basis, or maybe 2 times a day, releases the water that's stored very quickly in order to have the turbines move as quickly as possible to generate electricity and power. And then the dam is sort of shuts off and only has minimal flow moving after those peaking and releasing cycles. So what happens downstream to an aquatic system with that type of extreme variability in water levels? What happens downstream is that you don't have everything that you should have in terms of the diversity and number of aquatic species that support that particular ecosystem downstream. So there were periods historically where the sudden shutting off or tapering off of water flow would leave fish stranded high and dry. And also it's important to recognize that during the stream migratory fish passage season, that those types of dramatic changes can impede the ability for migratory fish to reach the fish lifts once they were in place at the Conowingo Dam. I think we all know that the release of nutrients and the downstream transport of nutrients as a final point impacts bay water quality by impacting dissolved oxygen levels, particularly in the deep channels of the bay. And the water, and obviously the trash and debris is a water quality issue as it moves down through the Susquehanna River and then ultimately into the bay. Next slide. So as Jonathan commented on a little bit earlier, the settlement agreement with Exelon has sort of 2 major component parts to it. The first are license articles that are enforceable by FERC. And the second is are provisions that don't go into the license, but are binding agreements to provide funding to support restoration of ecosystem services in the bay and in the Susquehanna River. So the combined investment by Exelon in environmental protection, mitigation, and enhancement measures for the 50-year term of the license is estimated at over about $200 million. So the license articles that are in the settlement agreement include conditions on flow, specifically conditions related to minimum flow, maximum flow, and controls on up-ramping and down-ramping. Up-ramping and down-ramping is just a way of describing sort of how quickly the water goes up and how quickly the water goes down as part of the operation of a peaking dam facility, hydropower facility. Second, provisions deal with fish and eel passage, increased investment under the settlement agreement in improving upstream eel passage, recognizing the importance of eels to the ecosystem, and not just for eels per se, but for the role that they play in the life cycle of freshwater mussels. There's provisions that relate to invasive species, which are becoming increasingly challenging in the Susquehanna River. Provisions associated with minimizing downstream transport of trash and debris. And then there are a handful of other provisions that relate to dissolved oxygen levels at the dam, shoreline management provisions, turtle management provisions, and waterfowl nesting provisions and sturgeon protection as well. The provisions which are not in the license but are binding agreements include a significant investment in mussel restoration, freshwater mussel restoration in the Susquehanna River, which includes land from Exelon for the creation of a new mussel hatchery. There's funding that is for resiliency projects and water quality projects. And then there's also funding for, excuse me, additional studies and funding to help support MDE and DNR in its oversight over the implementation of the settlement agreement over the 50-year term of the license. Next slide. So I've quickly went over just a minute ago. We're talking about within flow, we're talking to actions to mitigate the peaking operations of the facilities. Fish and eel passage, we include provisions that are about increasing the attraction flow so that American shad and river herring are better attracted to the fish lift. They have to be attracted to the fish lift and enter the fish lift in order to be to go up in the fish lift. There's monitoring requirements for invasive species and for removing those from the fish list when they're encountered. There are requirements for removal of trash and debris as much as is reasonably practicable. We expect between 50 and 450 loads annually to be removed. There's also a requirement for Exelon to remove any trash and debris that accumulates in downstream in the front of downstream drinking water intakes as soon as possible after any storm events. There are also requirements associated with DO monitoring and shoreline management, et cetera. Next slide. The freshwater mussel initiative is an investment. The settlement agreement provides $4.5 million, excuse me, during the first 3 years for the creation of a mussel hatchery, and provides $250,000 per year for the duration of the license to provide the operation and maintenance costs for the freshwater mussel hatchery. There are almost $5 million in the first year, 3 years that go to resiliency and water quality related projects, with a focus of the water quality projects being on nutrients primarily. There are also funds that are go to study eel passage. DNR is going to receive $1 million to continue to research how to maximize upstream eel passage in that system. There are a couple other provisions that relate to chlorophyll A monitoring and reimbursement of MDNR and MDE's oversight costs at about $150,000 per year. Next slide. So as Jonathan said, the settlement agreement was submitted to FERC last year, actually a little over a year ago. And it will become effective if FERC accepts the settlement agreement proposed license articles without modification or expansion. If they fail to approve the proposed license articles in full, the settlement agreement provides opportunity for Exelon and MDE to renegotiate or to terminate the agreement. There are a lot of words in there in the settlement agreement itself about how that process works, but that's sort of the bottom line. If it is terminated, the original water quality certification would remain in effect and litigation will resume.
Great, thank you, Denise. I appreciate all of that. At this time, I'm going to turn it over to Chip. Chip is got a lot of expertise in this area, and he's got a client, Clean Chesapeake Coalition, who's been very active in regards with the Conowingo Dam. So take it away, Chip.
Thank you very much, Sarah, and good afternoon to everybody. I'd like to first thank and compliment both Denise Keener and Jonathan May for their hard work on really one of the most vexing issues for the Chesapeake Bay, and that is what I often refer to as the Conowingo factor. They worked very hard on a complex issue, and so we're talking about the settlement agreement. The Clean Chesapeake Coalition, and I think it's important for context, is an association of Maryland local government elected officials. So these are downstream county government officials who have been paying close attention to what's happening with Conowingo Dam in terms of relicensing, and because of the role it plays in the health of the Chesapeake Bay. And I'm going to go through a few slides that really help continue to give you some context. And some of these are just pictures, but the Conowingo factor is a very important element of the Bay cleanup. And yes, you can go to this next slide. There's a picture of Conowingo Dam. When MDE issued its water quality certification for Conowingo Dam back in 2018, the Clean Chesapeake Coalition, our press release that day or the day after, really referred to it as a bold and historic agency decision. And the reason we said that is, indeed, the water quality certification issued by the state of Maryland for this particular facility is probably the most important agency decision on the Bay cleanup continuum. And it is that way because of just how large of a problem this is. So again, to give you context, and here's another picture of Conowingo Dam looking north. So what you see here, the rocks, that's on the downside, downstream side of the dam. To the left is really where the turbines are. You can go to the next slide. This is a picture at the gates, at the flood gates on the downstream side of the dam. And you can see the date. This was in September 2011. And I'm going to talk about this a little bit more. This is about Tropical Storm Lee. And if you go to the next slide. So again, to give context, in 2011, we had the second largest storm next to Hurricane Agnes befall the Chesapeake Bay watershed. And this particular photograph was taken on the 13th of September in 2011. It's a NASA photograph. And what it shows is a sediment plume extending about 100 miles south of the dam, all the way down to the mouth of Potomac River. And this just kind of visualizes the enormity of the problem with when a storm hits and what happens to all the accumulated sediments that are stockpiled above the dam. And we'll talk about that a little bit more. But again, keep in mind too, this is a picture of a sediment plume that occurred over a matter of days. And I'm going to show a little bit later the amount of pollution that is estimated to have been come into the Chesapeake Bay during this one storm event. And you have to keep that in mind when you hear about the pollution loading that occurs to the Chesapeake Bay throughout the year from various sources. Next slide. Again, this is the same picture. The Clean Chesapeake Coalition counties, which I should mention, the Clean Chesapeake Coalition formed back in 2012. And since that time, we've actually used this photograph as our calling card, just again to bring awareness to the issue. And what's been said, if you read, and you know that they say that Chesapeake Bay is one of the most studied bodies of water in the world. I believe that. It's obviously the largest estuary in the world as far as a body of water that mixes with fresh water and seawater, the salt water. It was mentioned by Denise Keener earlier about the Susquehanna River and the flow of water. The entire Bay cleanup agenda and what most people hear about the Chesapeake Bay and pollution sources, you often hear about pollution sources in terms of agriculture or septic tanks or stormwater management, meaning the runoff from streets and hard surfaces, or wastewater treatment plants. You know, local governments, if you will upgrade all your wastewater treatment plants and put in the latest technology to reduce pollution coming out of the pipe, we're obviously going to then reduce the pollution that's being dumped into the bay. And that has worked. With all the upgrades to wastewater treatment plants, you see less pollution coming into the bay from those treatment plants. However, the overall health of the Chesapeake Bay has not markedly improved over the years. And this is by no means an indictment or criticism, but there are groups that have been carrying the mantle of the Chesapeake Bay for decades and issuing report cards. And unfortunately, the health and water quality of the bay is not improving with any great measure. And we believe, and when I say we, the coalition county officials believe it has a lot to do with the amount of pollution that's coming from the Susquehanna River. And my remarks on this panel, I hope, if anything, leave the impression with folks that when you listen about the Bay cleanup and what's going on, to try to think of it differently in terms of where the pollution is coming from and what we have to focus on. Again, many of the programs and the whole Chesapeake Bay TMDL is premised on these pollution sources, but I think important for Marylanders, taxpayers in Maryland, and of course my clients, the county officials who are part of the Clean Chesapeake Coalition, they see the #1 source of pollution to focus on being the Susquehanna River. When you divvy up pollution into these various segments like septic and stormwater and farmers, it takes away or distracts really from what we believe is the problem and that needs to be addressed. That's the Conowingo factor, which is the accumulated sediments and pollutants that are sitting up above the dam. There's a 14-mile reservoir above the dam, and it's full and no longer traps. And whenever there's a storm, and it doesn't take much of a storm, which I'm going to show you later, we get scouring into the bay. Next slide, please. This gives you an idea of just sort of how the Conowingo Dam does work as a trap. In fairness to Exelon, the dam wasn't built for the purpose of trapping sediment and protecting the Chesapeake Bay from pollution. But Exelon has taken a lot of credit for that benefit to the bay, but that benefit is lost. There is no longer trapping capacity. So what happens, and you can see with this cross section, basically when you get turbulence and a high water flow, then you're going to get scouring out of that reservoir. And you have to visualize this is happening in enormous amounts of pollution over a very short period of time. And it's hard for the bay, especially the upper Chesapeake Bay, to assimilate this kind of pollution. Next slide, please. Again, just a little bit more important for the context and why I would advocate that when you're talking about how to help the Chesapeake Bay and when you're in Maryland, and remember, Maryland, we're downstream. Maryland has spent more to restore the Chesapeake Bay and the water quality of the Chesapeake Bay than most of the Bay states. Now, many say we have the most to gain. Okay, granted that. Others have said, well, no matter what, Maryland needs to lead, so the other follows. The other Bay states follow. To that, I would just observe this. There is now all of this rhetoric and, in fact, litigation now about Pennsylvania and how Pennsylvania is not doing its fair share to reduce the amount of pollution flowing into the Susquehanna, which eventually flows into the Chesapeake Bay. So if Maryland was to have led and that would have gotten other Bay states to do the right thing, we would have expected Pennsylvania to be coming along by now. That's not the case. And as much as we'd like to believe that kind of leadership would make the difference, it hasn't. And Maryland is bearing a disproportionate share of this cleanup because of the lack of activity upstream. But this slide just gives you an idea of the watershed that's draining to this one point. Another interesting thing about this, for those that follow closely, you know, the Clean Water Act and the permits that are issued to local governments that have pipes and conduits that reduce release pollution, the NPDES permits. You know, Conowingo Dam is a facility that this entire basin drains into. It's a pipe system that flows into the Chesapeake Bay, and yet it's not treated the same way as an outfall from a wastewater treatment plant. Next slide, please. This is just to show you it doesn't take a large storm event. It's said now that any flow at the Susquehanna River of 100,000 to 150,000 cubic feet per second is going to result in scour. Now, these slides, maybe they're difficult to see, but this is actually to show that it doesn't even take a storm. These are the slides of the Chesapeake Bay from the same NASA satellite, but it's showing the sediment plume that occurred after the spring melt in 2015. And by the spring melt, this is all the snow and ice upstream, Pennsylvania, New York, that just, they had a lot of snow that winter. And this is the impact of all that snow and ice on the Chesapeake Bay later in the spring. So this wasn't a tropical storm or a hurricane. This was just snow melting. And yet you can see the plume of sediment that's resulting from the scour. Next slide, please. And you can go on to the next slide. That's just more detail about that flow event, that spring melt. Next slide, because I want to get this again, goes to how much pollution comes in during these storm events. So a little bit about the legal framework and how we've been approaching this issue. You have the total maximum daily load, the pollution diet that was established by EPA back in 2010. It's important to note that pollution diet, TMDL, was the result of a lawsuit that was filed by the Chesapeake Bay Foundation against EPA to try to get EPA to do a more affirmative enforcement of pollution reduction goals as opposed to being voluntary. And then you fast forward to today, where we have another Chesapeake Bay Foundation lawsuit against EPA relating to Pennsylvania, the enforcement of Pennsylvania doing their fair share. And some are speculating if that won't result in some other change to the Chesapeake Bay TMDL. I want to mention one more thing. I think my time's almost up. Watershed implementation plans are an important part of the Bay TMDL. We think right now the most important focus needs to be on a Conowingo specific watershed implementation plan, or WIP, that is actually being drafted now and is out for public comment. That's a very important part of the next step for the Bay cleanup. And if I could just go to one more slide, please. And just to point out, the reason it's important about the Bay TMDL and how much we've focused, the original 2010 Bay TMDL Appendix T had an assumption that was way off. It assumed the Conowingo reservoir trapping capacity would be there till 2025. Based on a report by the U.S. Geological Survey in 2012, it was determined that equilibrium had already been achieved. So the Bay TMDL since 2010 was off as far as the coalition counties were concerned. And the result of that was coming up with this Conowingo WIP. And next slide. I just have to point out one more thing. And again, this is just to give everybody a different perspective about this issue or the problem, and why the coalition counties thinks it's so important to focus on possibly dredging. The we spend a lot of money, and I will estimate about $1 billion a year in Maryland below the dam. Every 10 years, I'm sorry, every decade, we spend about $1 billion dredging shipping channels in the upper Chesapeake Bay to keep the Port of Baltimore viable. 80 to 85% of what's being dredged out of shipping channels is coming from the Susquehanna River. It's not upper bay erosion. So that is in itself a big problem, that we're spending all that money chasing sediments and we're not doing anything to get them while they're sitting above the dam. And next slide. And with that, I'll be quiet. Thank you.
Thanks, Chip. Thanks very much for all that information. So I'm going to read a couple of the questions that we've got here in the chat. So we've got a question from Joanne, which may require some speculation on the part of the panelists. What might be questions or concerns at FERC that would make them not approve the settlement?
I'll take a cut at it. This is Denise Keener. I think that, so one of the things that we all have to recognize is that this Conowingo relicensing has been going on since, I think, 2012 is sort of when the first overture was made by Exelon to the Federal Energy Regulatory Commission. In those many years that have passed, we have a fish prescription from the U.S. Fish and Wildlife Service. We have FERC's own staff recommendations about what is the most appropriate flow for the Conowingo Dam as a hydropower facility. So what I would say is that on a number of the provisions that are associated with recommendations that MDE and Exelon made in the settlement, I shouldn't recommendations, they are kind of, it's in the settlement agreement. They're not exactly what is in, for example, the fish prescription. It's not exactly what's in the staff recommendations at FERC regarding what is the proper flow regime that balances ecological benefits with hydropower, generation. So I would say that it's that, kind of an issue where there are different opinions about the same topic, and they're not exactly all identical.
Thanks, Denise. Jonathan, did you want to weigh in at all?
No, I actually think Denise said it very well.
Chip, did you have anything to add on to that one?
Yeah, well, I think I would just add probably from there are many groups that are paying close attention to what FERC is going to do with this proposed settlement agreement. Many thought there was going to be a decision lickety-split out of FERC about a year ago, when all this legal landscape, as Jonathan went through about the cases and all that. And here we sit. And I think from the Clean Chesapeake Coalition Counties point of view, and probably some other environmental groups, no news is good news if FERC is actually looking closely at this agreement and all the elements. And again, as I said earlier, like as most settlement agreements, you have most people upset with it or not happy because it's a compromise. And, people, compromising from what you really believe is sometimes hard. So we understand the context of the settlement, but if FERC taking their time means maybe there'll be some additional conditions. I mean, there's some that are very important to the coalition counties, like a mitigation fund, and a little bit more on looking hard at the dredging aspect. But again, we do look at this amount of time it's taken as a curiosity, but boy, it's hard to interpret what FERC is thinking.
Yeah, that much is for sure. Thank you for that. So we've got two more questions. Hopefully we can wrap these up quickly. One other on the settlement agreement while we're there. So does the settlement agreement include dredging and removal of materials in the reservoir upstream of the dam? Is there any reason why it would not be included?
Well, I'll just quickly say that the settlement agreement has a provision for $500,000 to study sediment disposal study. Look, that's great to continue studying, but again, the folks that I represent would say this is very simple. If you look at the reservoir behind Conowingo Dam and you step way back, that's the largest stormwater management pond in the whole Bay watershed. And if it's not dredged, then everybody knows what's going to continue to happen. And we dredge stormwater management ponds all the time. Developers of shopping malls, farmers, that's what we do. That's what this is functioning as. And yet we're pretending it's something we can address by just stopping all the pollution from ever getting to the reservoir. Now, I'm an optimist. One day, Pennsylvania will get their act together and there'll be less pollution going into Susquehanna and coming our way. But that may take decades. I mean, we all need to be very honest about this. Even this lawsuit against Pennsylvania, how quickly, honestly, will Pennsylvania curb the amount of pollution that's flowing towards us downstream?
I think we're going to hear about that next session. I don't mean to leave questions unanswered, but I think we need to move on so we don't take any time away from our next group. So I want to thank Chip and Denise and Jonathan. That was a valiant effort at a complex topic in a short amount of time. Thank you very much. We really appreciate your expertise. And sorry, Fred, that we didn't get to your question, but stay tuned. We'll be coming back at 3 o'clock for our session on the Chesapeake Bay Foundation versus the EPA. Thanks, everybody.
Thank you.